Welcome to my YouTube channel Educationopedia, the School of Future. Today we are going to deal with social science topic of grade 8th. The topic is understanding our criminal justice system. You can see the criminal justice system or the criminal procedures are there in under which the court punishes to different people in the cases and the crime which they have done. When we see someone violating the law, means breaking the law, we immediately think of informing the police. We go to the police station to do something. You might have seen either in real life or in movies police officers filing reports and arresting persons. Yes, we all have seen that in movies, especially. In normal life, we never go to police station or we don't want to go to such place. That's why we have seen all these things in movies. Because of the role played by the police in arresting persons, we often get confused and think that it is the police who decide whether a person is guilty or not. So what is our clear conception or our mindset is, if I ask you all, you will say that yes, police is only the person, he catches the person and he gives the punishment. Most of the people will say like that only, but it is not so. This, however, is far from true. After a person is arrested, it is a court of law that decides whether the accused person is guilty or not. According to the constitution, you know that our country is run by a rule book. There is a set of certain rules which are mentioned in the Constitution of India, and we are governed by that. So according to that constitution, every individual charged of a crime has to be given a fair trial. The four key players of the criminal justice system are the police. So first key player is the police. There is certain rules and regulations mentioned for the police, what he has to do, how he has to do, and what actions he can take. The public prosecutor. Public prosecutor is the person who will fight for the guilty person, and that particular, he is a lawyer basically, and he is provided for the particular person who is convict, not criminal. And the defense lawyer is there from the opposition party, and the judge. So four key players are there: the police, the public prosecutor, the defense lawyer, and the judge. You have seen the roles each of them played in the above case. So in the above case, you have seen that what role they have played. Now let us try and understand their roles in more generally. So generally what their role is, that we need to understand. What is the role of the police in investigating a crime? So how does police investigates a crime? One important function of the police is to investigate any complaint about the commission of a crime. Means a crime has been committed and it has taken place. So it is the important function of police to investigate that. It has to reach at that point and search for the different evidences and different things which it can collect regarding the incident happened. An investigation includes recording statements of witnesses. Witnesses in Hindi we call them as gawah, means who has seen that particular thing, who was present at that particular moment, and he knows that what really happened. Those persons are known as witness. And collecting different kinds of evidence. Another thing is the evidence. It is something which is physical in nature, or it can be something else also. So basically the physical evidences are collected from the place where the incident has took place. On the basis of the investigation, the police is required to form an opinion. So what is that opinion? Means it will clearly say that yes, it seems that something like this has happened and it is the reason behind this particular thing. If a police think that the evidence points to the guilt of an accused person, then they have file a charge sheet in the court. So first, it is not directly that the person is accused. If from all the evidences collected, it appears something like that yes, this particular person is guilty or something is there, then it files a charge sheet in the court that we want this person on remand, or we want to have some arrest that person. Police investigations always have to be continued in accordance with law and full respect for human rights. So you all know that we all have some human rights, and that human rights must not be violated while this procedure of investigations is going on, and for that Human Rights Commission is also taking care. The Supreme Court has laid down some guidelines that the police must follow at the time of arrest. So when the police is going to arrest certain person or anything such kind is going to happen, at that time certain guidelines the police has to follow, which they need to follow, and those guidelines are important for the procedure to be completed. The arrest, detention and interrogation. So police will arrest them, it will detention them, and finally it will interrogate them. Whatever things are there, it will find to each and everything. It will take the statements of different persons, it will collect small to small information, evidences, etc. The police are not allowed to torture or beat or shoot anyone during investigation. So we normally see in the movies that something is happening, but really if a person is aware about its right, it is clearly mentioned that no, they cannot do like this, they cannot beat someone or they cannot torture someone for getting something confessed during investigation. Fundamental rights. So what are these fundamental rights? They cannot fundamental right, they cannot inflict any form of punishment on a person even for petty offenses. If anything has been done by the criminal, any small to small, any very harsh to harsh thing has been done by the criminal, police is not allowed to do some physical torture to them. Article 22 of the Constitution and criminal law guarantee to every arrested person the following fundamental rights. So there are certain fundamental rights for the persons who are arrested, who are in jail also. The right to be informed at the time of arrest of the offense for which the person is being arrested. Police cannot arrest you like that what you have not done. It has to explain you, it has to say that yes, we are arresting you in this particular event. Next is the right to be presented before a magistrate within 24 hours of arrest. Suppose now it is 6 p.m. in the evening or 6 a.m. in the morning, then by the next day 6 p.m. in the morning, according to 6 p.m. in today in the morning and 6 p.m. tomorrow in the evening as compared to 6 p.m. today in the evening. So after 24 hours it is necessary that the person must be presented in a court, or that is a magistrate court or district court. The right not to be ill-treated or tortured during arrest or in custody. So when he is in police custody or remand, at that time police cannot torture him or ill-treat the person who is in the jail. Again, confessions made in the police custody cannot be used as an evidence against the accused. If something has been told by the accused in the police station because police were torturing him, beating him properly, so that statement is not considered. Later if the child says or that particular minor says that this is the type of, or the person says that this, it has been told to me to forcefully say this particular thing, then that statement does not mean have had any evidence. A boy under 15 years of age and woman cannot be called to the police station only for questioning. You need to understand that any boy who is not 15 years and above, and the women who are working, or women who are not working, women who are there, any sort of woman cannot be called in the police station at night time or in the evening for questioning also. You can see that the fundamental rights is there, what the definition is there. Fundamental rights are essential human rights that are offered to every citizen irrespective of caste, race, creed, date of place of birth, religion, place of birth, religion and gender. The gender. These are equal to these are equal to the freedoms, and these are equal to freedoms and rights. These rights are essential for personal good and society at large. So it is giving benefit to most of the persons. Fundamental rights in India, you can see what are they. That is basically the preamble: we the people of India, whatever justice, social, economic and political rights. Fundamental rights means peace, hope, freedom, all those things, equality, fraternity, and you can see a police officer investigating. D.K. Basu guidelines. The Supreme Court of India has laid down specific requirements and procedures that the police and other agencies have to follow for the arrest, detention and interrogation of any people. If the police is going to arrest any person, interrogate any person, detention to any person, and it has to first do or certain rules, follow certain rules and regulations, and that rules and regulations is also only known as the DK Basu guidelines. And some of these include, so what are the basic things in DK Basu guidelines? We'll see to it. First one is your, the police officials who carry out the arrest of integration should wear clear, accurate and visible identification and name tags with their designation. So whatever uniform they are wearing, that should be clear, and whatever name tag or whatever position they are, that should be mentioned on their chest. You know, on right left side they are having a small tag like thing. A memo of arrest should be prepared at the time of arrest and should include the time and date of arrest. So when the person is arrested, there everything is written on a piece of paper, government paper is there. On that only the signature of the magistrate and other persons and the criminal himself, or criminal not, accused himself, is mentioned there. DK Basu guidelines. It should also be attested by at least one witness who could include a family member of the person arrested. So your family member, if he has been arrested from a family or any occasion, in that case there his signature will be required. Next is arrested, the arrest memo should be countersigned by the person arrested. So if I have been arrested, so whatever charge is on me, they will give me the paper, there I have to put signature. If I feel that yes, it is wrong or right, whatever, then we can move on with that particular thing. The person arrested, detained or being interrogated has a right to inform a relative, friend or a well-wisher. So if some police is arresting me, at the same moment I can call to my well-wisher, relative, friend, relatives, whomsoever is there, that in this manner I have been arrested, please do something for me. When a friend or a relative lives outside the district, the time, place and arrest and venue of custody must be noticed by police within 8 to 12 hours after arrest. So if the person is not living nearby or is living to a relative, so at that time 12 hours time is being given to arrest them. Next you can say first information report or the FIR. What is first information report and FIR? We will see to it. It is with the registration of the FIR that the police can begin their investigations into a crime. The law states that it is compulsory for an officer in charge of a police station to register an FIR whenever a person gives information about a cognizable offence. So which is a cognizable offence or a punishable offence? If any person has come with a complaint, the police has to lodge that complaint or file that complaint. Next, this information can be given to the police either orally or in writing. So person can say also, sir, this thing has happened with me. So on that basis also police should keep it in mind. Otherwise they will give you some amount or something so that you can recognize that thing easily. The FIR usually mentions the date, time and place of the offense, details the offense, details the basic facts of an offense, including the description of the events if known, the identity of the arrested person and witnesses are also mentioned. So all these things need to be mentioned in that particular report. First information report, FIR. The first information report also states the name of and address of the complainant. So who is the complainant or the person who has filed the complaint? His all things are provided there. There is a prescribed form for which the police registers an FIR and it is signed by the complainant. So complainant also signs that. Those who have done complaint, so whatever report it has been, will send the paper, he will take your signature. The complainant also has a legal right to get a free copy of the FIR from the police. So a free copy of what charge has been put on that particular person will be provided by the police to the person in accused. FIR form is in next slide. So this is your FIR form. It is an example is there. First information report, Pratham Suchana report, like that it is under section 184 CR PC. So criminal procedure code is there, or IPC there, international Indian Penal Code. So the IPC Indian Penal Code is there, under that it comes. So this is your criminal procedure code under IPC. So this here all the things are there. District you have to mention, village you have to mention, year you have to mention, FIR number you have to mention, then what act have been put on you, like different acts are there, sections are there in the Constitution of India. According to that you will get punishment. What is the role of the public prosecutor? So the public prosecutor, who represents the interest of the state, means from the government side he is filing. The role of the prosecutor begins once the police has conducted the investigation and filed the charge sheet in the court. So once the charge sheet has been filed in the court, once the police has completed investigation, then the role of public prosecutor comes. The prosecutor must conduct the prosecution on behalf of the state. So from the behalf of the state, so is the Supreme Court, country, etc. So on that behalf of that particular person, their charge sheet is filed. As an officer of the court, it is his or her duty to act as an impartially and present the full and material facts, witnesses and evidences before the court. So whatever is the truth, that has to be produced by that person at the end, whenever the court is adjourned before that. Next, witnesses evidence before the court to enable the court to decide the case, and in this manner the court is able to decide the case. Next, what is the role of the judge? The judge is like an umpire of a game. Umpire means, you have seen in cricket, the umpire is there and conducts the trial impartially and is in an open court. So in an open court, many people are sitting there. There only the court goes impartially what has happened, she explains, and what things have to be done in the future, that is being decided. Next, the judge hears all the witnesses and any other evidence present by the prosecution and the defense. The judge decides whether the accused person is a guilty or innocent on the basis of the evidence presented in accordance with the law. So whichever thing is there, you need a proper evidence to prove that thing. That's why police is collecting evidence, so that it may be able to prove and reach to the conclusions of most of the problems. If the law accused is convicted, then the judge pronounces the sentence. So if the accused is convicted, means he is being punished or he has been charged. In that case, judge pronounces the sentence, means what punishment has been given, that is there the word sentence. He may send the person to jail or impose a fine on both. So either he may send them to jail or he will impose a fine on them. Fine on both, depending on what the law prescribes. So what the law says, according to that only the person will do. Next, what is a fair trial? Article 21 of the Constitution, that guarantees the right to life, states that the person's life and liberty can be taken away only by the following reasonable and just legal procedure. So nobody life you are supposed to take off. A fair trial ensures that Article 21 of the Constitution is upheld. So fair trial means that whatever is given in the Article 21 of the Constitution, if all those things are fulfilled, means it is a fair trial. Here are my case papers. I have been falsely accused of stealing my employer's gold chain. They found rupees 10,000 in Shanti's trunk and said that this is the money she got from stealing the chain, but this is the money that we have been saving up together. So Shanti has to send some money to the village, and one of his relatives in his old owner's house was there, and somebody stole a gold chain, and it was the people or the boys nearby in the society who were doing drug addicts, so they were using that particular thing. So what the thing is there, she has been accused and now the case is going on in the court. What will happen to save her? Let's see the next slide. Firstly, Shanti was given a copy of a copy of a charge sheet and all other evidences that the prosecution presented against her. Shanti was charged with the offense of theft that was defined as a crime in the law. So if you are doing a theft or you are stealing something, you are under a crime. The trial was held in an open court in public view. So whatever trial took place, that was in an open court in the public view. Next is her brother Sushil could attend the court hearing. So Sushil was also attending the court hearing and he heard the things. Sushila could attend the court hearings. The trial was held in the presence of accused. So Shanti was the accused. In her presence only the following decisions were taken. Next is Shanti was defended by a lawyer. So Shanti got a lawyer from the government and she was defended by him, and whatever problem was coming, the teachers were taking support of the states and they wanted to have the particular thing. Shanti was defended by lawyer. Shanti's lawyer, Advocate Roy, was given an opportunity to cross-examine